I fully understand that this is a momentous decision for a president. And if the Senate does me the honor of confirming me, I pledge to discharge the responsibilities of this job to the very best of my ability.
Judge Amy Coney Barrett is President Donald Trump's nominee for Supreme Court to fill the vacant seat of the late Justice Ruth Bader Ginsburg. Barrett has been on the 7th U.S. Circuit Court of Appeals since 2017.
I stand before you today to fulfill one of my highest and most important duties under the United States Constitution, the nomination of a Supreme Court Justice. Over the past week, our nation has mourned the loss of a true American legend. Justice Ruth Bader Ginsburg was a legal giant and a pioneer for women. Her extraordinary life and legacy will inspire Americans for generations to come. Now we gather in the Rose Garden to continue our never-ending task of ensuring equal justice and preserving the impartial rule of law.
Amy Coney was born in New Orleans, Louisiana in 1972. She studied English literature at Rhodes College in Tennessee and graduated in 1994. She went on to study law at Notre Dame Law School on a full tuition scholarship and graduated first in her class in 1997. In 1999, she married fellow Notre Dame Law School graduate Jessie M. Barrett. The couple lives in South Bend, Indiana, and have 7 children, 2 of whom were adopted from Haiti. Before President Trump nominated Barrett to the 7th Circuit Court of Appeals in May 2017, she was a professor at her alma mater, Notre Dame Law School, where she taught constitutional law, originalism, statutory interpretation, and stare decisis. If appointed to the Supreme Court, Barrett will be the youngest current judge at 48 years old.
Amy is more than a stellar scholar and judge. She's also a profoundly devoted mother. Her family is a core part of who Amy is. She opened her home and her heart and adopted 2 beautiful children from Haiti. Her incredible bond with her youngest child, a son with Down syndrome, is a true inspiration. If confirmed, Justice Barrett will make history as the first mother of school-age children ever to serve on the U.S. Supreme Court.
Yesterday, before Justice Ginsburg could be laid to rest, and after thousands of Americans had already cast their ballots, the President nominated a successor to her seat. There's no mystery about what's happening here. President Trump is trying to throw out the Affordable Care Act. He's been trying to do it for the last 4 years. The judge has a written track record of disagreeing adamantly with the Supreme Court's decisions on 2 occasions upholding the ACA. In fact, not as a judge, but prior to going on the bench, she publicly criticized Chief Justice Roberts' opinion upholding the law 8 years ago.
In a 2017 essay written at Notre Dame called Countering the Majoritarian Difficulty, Barrett argues that judges should respect the text of laws and contends that Chief Justice John G. Roberts Jr., who wrote the majority opinion the first time the Supreme Court upheld the healthcare law, pushed the Affordable Care Act beyond its plausible meaning to save the statute. This is an issue Joe Biden and Kamala Harris have cited in the campaign trails, arguing that Barrett could be the vote conservatives need to overturn Obamacare.
Judge Barrett is on record opposing the decision that upheld the Affordable Care Act. As recently as 2017, she specifically attacked the Chief Justice's opinion in an article where she said, quote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. If nothing else, the voters should be very clear about one thing. President Trump and his party and Judge Barrett will overturn the Affordable Care Act, and they won't stop there.
Barrett has twice joined dissenting opinions asking for decisions blocking laws enacted by abortion opponents to be thrown out and reheard by the full appeals court. In 2019, after a 3-judge panel blocked an Indiana law that would make it harder for a minor to have an abortion without parents being notified, Barrett voted to have the case reheard by the full court. In 2018, a 3-judge panel ruled that Indiana laws requiring that funerals be held for fetal remains after an abortion or miscarriage and banning abortions because of the sex, race, or developmental disability of the fetus were unconstitutional. Barrett was among 4 judges who wanted the full court to weigh in and suggested that the laws, signed by then Governor Mike Pence, might be constitutional. I think it is very unlikely at this point that the court is going to overturn Roe v. Wade. The fundamental element that the woman has a right to choose abortion will probably stand, she said at a 2013 lecture at Notre Dame on the 40th anniversary of the Roe v. Wade ruling. Despite her anti-abortion views, Barrett has stated she believes Roe v. Wade being overturned is unlikely and maintains her stance on upholding precedents. If the court's opinions change with its membership, public confidence in the court as an institution might decline. Its members might be seen as partisan rather than impartial, and case law as fueled by power rather than reason, she once wrote in Texas Law Review. Leaving room for new majorities to overrule old ones allows changed membership to change what the court says the Constitution means, she wrote.
A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold.
They have made clear that they want to overturn Roe v. Wade and restrict reproductive rights and freedoms. Judge Barrett has a long record of opposing abortion and reproductive rights. There is no other issue that so disrespects and dishonors the work of Justice Ginsburg's life than undoing the seminal decision in the court's history that made it clear a woman has a right to make decisions about her own body.
In a dissent in the 2019 gun rights case of Cantor v. Barr, Barrett famously argued that a conviction for a nonviolent felony, in this case mail fraud, shouldn't automatically disqualify someone from owning a gun. The 2 judges in the majority agreed with Trump administration arguments that the defendant, Ricky Cantor, could not own a gun under federal or Wisconsin law because of his criminal conviction. Barrett used most of her 37-page dissent to lay out the history of gun rules for convicted criminals in the 18th and 19th centuries. Consistent with her embrace of interpreting laws and the Constitution according to the meaning they had when they were adopted. Barrett wrote that while both Wisconsin and the United States have an unquestionably strong interest in protecting the public from gun violence, they have failed to show, by either logic or data, that disarming Cantor substantially advances that interest. She said that her colleagues were treating the Second Amendment as a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. Barrett wrote a unanimous 3-judge panel decision in 2019, making it easier for the men alleged to have committed sexual assaults on campus to challenge the proceedings against them. The case involved allegations by a female student at Purdue University that her boyfriend had sexually assaulted her. The students were identified in court documents as John and Jane Doe. John Doe sued in federal court, claiming sex discrimination after Purdue suspended him for a year and took away his Navy ROTC scholarship. Barrett concluded Purdue's process was unfair and allowed his lawsuit to continue. Barrett is vocal about her Catholic faith, but maintains her stance that religious views do not get in the way of her duties as a judge. If you are asking whether I take my faith seriously, and I'm a faithful Catholic, I am. Although I would stress that my personal church affiliation or my religious belief would not bear in the discharge of my duties as a judge, she said at her confirmation hearing in 2017. A judge may never subvert the law or twist it in any way to match the judge's convictions from whatever source they derive, she said.
The President has nominated me to serve on the United States Supreme Court, and that institution belongs to all of us. If confirmed, I would not assume that role for the sake of those in my own circle, and certainly not for my own sake. I would assume this role to serve you. I would discharge the judicial oath, which requires me to administer justice without respect to persons, do equal right to the poor and rich, and faithfully and impartially discharge my duties under the United States Constitution. I have no illusions that the road ahead of me will be easy, either for the short term or the long haul. I never imagined that I would find myself in this position. But now that I am, I assure you that I will meet the challenge with both humility and courage.